Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 133 of the podcast. Thank you for listening, supporting me for the last 2.5 years. As we begin the year, I'm getting phone calls now for people that are looking to renew their leases or perhaps getting into a brand new lease. And I've spoken to a number of clients, and in the podcast, actually, I've addressed lease agreements in the past. But today I want to talk about lease agreements in a different context, how lease agreements can end up in litigation, how commercial lease dispute can end up in litigation between landlords and tenants. And I want to talk about some examples that I've had in the past to perhaps give you some food for thought about some things to avoid in the future. And I'll give you an example. Say you go into a lease agreement and then you want to, in the type of business that you have, you want to open some type of distribution warehouse for your business, say called Amazon Distribution Warehouse. And the landlord tells you, yes, this type of business you can run here in this location. You don't go ahead and look at the whether or not it's zoned for that. You don't check with the city, and you go ahead and sign that lease. You take your lease to the city to get your business tax receipt. It's also commonly used to be known as the occupational license. And the city tells you, goes into the type of business you're going to run in this location, and then find out that no, this business it's not zoned for that. That location is not zoned for that. So then you go back to the landlord and say, listen, I cannot run this business here. I need my money back. And the landlord says, no, I'm not going to give you your money back because your responsibility to make sure you have the proper zoning. Technically, that is incorrect, but let's just use this example for the sake of this conversation. There's a lease dispute that occurs because by the time that you signed the lease, you already put a deposit into this place. Sometimes first month, last month is security deposit. You sign a personal guarantee, and then you cannot run your business. That's just one example. Another example that comes to mind is that you go ahead and sign the lease agreement, and unbeknownst to you, there were some repairs made in that location. And in the past, the city put some code violations for perhaps that they were done some type of illegal structure, perhaps some electricity that was done without proper permits. And there's some permitting violations in that property that you're about to lease. And you did not know about that, nor it was disclosed, which it should have been disclosed. You signed that lease, you put your first and last security deposit, and then you go back to the city to get your occupational license or the business tax receipt, to get your business license to be able to operate your business in this location. And they tell you, well, we cannot give you that, the business tax receipt, because there's some code violations with that property for some work that was done in the property. This case was electricity. Some electricity work was done without proper permit and will not pass inspection. So what do you do then? So obviously what most people do in this case is call an attorney, which is the right thing to do. In some cases, I have situations that people handle it themselves, which I've spoken about, that it's just not a good idea to handle a lawsuit by yourself. In one occasion, years past, the landlord, despite of the fact that did not disclose the zone violations, ended up suing my client. And we ended up getting it resolved, but it involved attorneys to get it resolved. So how do you avoid this? How do you avoid having your lease turn into a legal nightmare? This, a type of litigation, you're in a disadvantaged position when you're having a lawsuit with the landlord. the contract that you have, the lease agreement, it is not for the benefit of the tenant. It is a benefit for the landlord. And as I'm given, retained to review lease agreements, and they tell me, is there anything I should be concerned about? Well, that's a very broad question. If you're concerned about everything, the reality is this lease agreement is there to protect the landlord, although you as the tenant have some protections that are within the contract and also within the statute. It is not really designed to protect you, but you have some protections, nonetheless. So the first thing you need to do is understand that lease. And my recommendation is to have an attorney who has reviewed leases in the past and understand these leases to help you, guide you through this process. If you have never seen a commercial lease before and you're given one and you review it on your own, you're not going to understand it. It's usually a 25 to 30-page document. There are a lot of provisions there. If you do not know what to look for, you're going to be at a tremendous disadvantage. So the first thing is understanding your lease agreement, understanding its provisions, understanding your obligations, understanding, what would happen in the case that you don't pay the rent, understanding what would happen in the case there is a leak in your location. What remedies do you have to have the landlord to be able to repair those? What notifications you have to give the landlord to give the landlord's notice that if it's not repaired within a certain period of time, that you'll vacate the premises. So there's some rights that you have, but an attorney that understands this can help you with it. So how does this lease disputes begin? They usually begin, very common is missed rent payment. That is very common. You have a succession of missed payments that take place, and then the lease turns into a default. That seems to be a very common occurrence, and it might be the business has shorter cash flow. A lot of different factors that can go into why a tenant misses a payment. But usually sales are low and some expenses went higher. Prioritization and in terms of prioritizing that lease. And next to payroll, lease probably will be, in a small business context, one of the highest expenses, depending what type of business you're in. Okay, so if there are missed rent payments, usually 1 month is not going to really, get you into a into a eviction situation. But if you start missing 2 or 3, yes, you'll end up in an eviction situation. So the first thing is that if you anticipate having a missed payment for whatever reason, it's called the landlord beforehand and let the landlord know to see if any type of accommodation that can be made. And in most cases, landlords are reasonable and say, yeah, okay, they'll give you an accommodation. But if it continues to happen, then they do have an obligation to protect that property and have somebody there that is paying the rent. And there are penalties associated with that. It's very common to have a $25 charge if you miss a rent, or even higher. So understanding what happens when you miss the rent payment is significant. Another one that happens very often is dispute over CAM charges or management charges. So the way the CAM works is they give you, they charge your rent. If it's a triple net rent that you pay CAM, you pay property taxes and real estate taxes. They give you an estimate of what it's going to cost for the year. And based on that estimate, they charge your rent and they charge your CAM charges. Okay. So at the end of the year, they do a reconciliation, and then they find out that their estimate was lower than what actually cost. So you get this bill for reconciliation on the additional expenses that they incurred that you were not charged for on those monthly payments. Yes, you budgeted for a certain amount, and then you end up getting a $5,000 or $10,000 bill at the end of the year. So, and then you have a dispute about why you're getting this additional $10,000 invoice when you were paying camp charges. Then people decide not to pay the rent, and it escalates from there. Another area that happens often is maintenance and repair disagreements. And I'll give you an example of that is that, say you have HVAC unit that all of a sudden stopped working. Your lease is 3 years in. You have a 5-year lease with an option to renew. But when you moved into that building, into that office space or lease space, you did not check how old the unit was. You did not check whether the unit was 10 years old or 5 years old, or when that unit was installed. So the unit stopped working, and then you tell the landlord, listen, the AC is not working. I need to have somebody check it and repair it for me. The landlord tells you that's your responsibility, send the lease. You got to bring somebody in to look at it, and if you cannot repair it, you got to replace it. You did not know that, and that's something that you should have known if you would have received the lease. And I say you as an example, just more as a business owner, that you should know this lease. And in this case, what happens is that you go ahead and call the repair company, the AC repair company, to look at it. They said the unit is shut, has to be replaced. And then to replace the AC unit, you're looking at $10,000 or $15,000. He said, well, I'm not going to repair that. I'm going to be here another 2 more years. I don't want to go ahead and give them a brand new unit. So that's where disputes arise. How to avoid that is to understand your responsibility, especially for high-ticket items. And that can be negotiated at the beginning of the lease. It can be negotiated at the renewal of the lease. But understanding what is your responsibility regarding high-ticket items in terms of repair and maintenance of that unit is essential for you to understand what potential expenses you might have in the future and what potential risk you have with respect to the property that you're leasing for your business. Another area that I see happen very often with lease agreements is that you have a property manager in the premises, and say it's a strip mall, you have a property manager, and then you have your landlord, okay? And then the property manager makes informal agreements with the tenant with respect to late payments, with respect to repairs or maintenance, but that's not in writing anywhere. And what happens is that, you start getting the rent, say 10 days late, and all of a sudden you get this eviction notice because you're in default of the lease. Or another example is that you don't do the repairs that you needed to do, or you were promised by this property manager, no, we have somebody coming in and make the repairs, don't worry about it. It is not in writing, and it's not a modification of the lease. And then you get a 3-day notice to vacate, and then you call my office. And I said, okay, so what happened here? And I often see a succession of informal agreements that take place with a property manager, via text, sometimes via email, sometimes they say, no, I don't have any documentation. And those are not binding unless it's in writing, especially in the context of a lease agreement. If I give you any type of advice here, and every situation is different, I want to be clear about that, is that if you're going to have any type of concession or modification to anything regarding the lease, is to get it in writing by someone who has the authority to bind the landlord, and do it in a way of an amendment to the lease agreement. So that way it becomes part of the lease agreement, and it's not an informal agreement, quote unquote, that was made. So those are one of the things that I see here, and also what I see also often happen is that there's no communication between the landlord and tenant after dispute arises, and then that's where legal gets involved. The landlord transfers the file to the legal department or to the law firm that represents the landlord, and then litigation continues. Um, it is very easy in Florida to evict a commercial tenant. Let me repeat. It is very easy for a landlord of a commercial property to evict a tenant. Uh, you get a 3-day notice to vacate, especially in the case of late payment. Uh, and if you don't pay with the amount that is owed or vacate, they can have proceedings to evict you, to summary proceedings, and you can be evicted in 5 days. They can get the order from the court. So the process is very fast. So you don't want to be in a situation that you're getting in that corner, because it becomes then a desperate situation trying to stop it. There are remedies to that to try to mitigate that from happening, or reduce or not, or stop that from happening, but you have to get an attorney involved for that to take place. There's some mechanisms that we have to be able to avoid that, and that goes beyond the scope of what we're trying to do here. But the key here is that if you're in a situation that you're getting a 3-day notice to vacate, you got to call an attorney. It's very important. This is something that you do not want to do yourself. And you especially do not want to, like I've seen done in the past, is that some business owners get desperate, and what they do, instead of calling an attorney, they send letters to the judge and explain everything. Uh, or they try to negotiate while this is taking place. You get the notice of eviction, you get served with that lawsuit for expedited proceedings, and instead of calling an attorney, the business owner begins to negotiate directly with landlord's attorney about a potential settlement, and starts making concessions and start making offers, uh, and sends a letter to the court explaining everything that was offered here, and it becomes a complete disaster. The best thing to do in this case is to call an attorney who understands this and be able to advise you on how to handle it. Because by the time it comes to the attorney and all this has transpired, there might be admissions that have been made along the way, and that might not be beneficial to you. So, as you have heard my podcast in the past, if there's any advice here, if you have a legal dispute, call an attorney. Don't handle it yourself. The exposure that especially small business owners have, sometimes is a personal exposure. In many cases, actually, because you have personal guarantees that are signed to guarantee that lease. And depending how much time you have on that lease, okay, that will determine the exposure that you have. So you have a situation that you have a 5-year lease, and then in year one, a dispute arises, whether it's a failure to pay, or whether it's a maintenance or repair issue, whether it's an unfulfilled promise, whether it was landlord's work that was promised but it was not performed. There are just many different areas where you can have a dispute between a landlord and tenant uh, that can lead to litigation. But then you have a personal guarantee as well. So what happens is when someone is sued on a commercial lease, the business is sued. So that inevitably will require you as the business owner to obtain an attorney, unless it's small claims. And very unlikely you will have a situation where you have a small claims action less than $8,000 in Florida to be a landlord-tenant dispute, a commercial landlord-tenant dispute. That's going to go to county court or circuit court. In that case, the company needs to get an attorney. the business will have to get an attorney, unless it's a sole proprietorship. But if it's an LLC, a corporation, like most of them are, an attorney must represent the company in Florida. But they also will sue you as the business owner if you sign a personal guarantee, and it's very likely that you did if it's a small business and a landlord commercial lease agreement. So the exposure becomes greater because you personally signed, but it's also for the balance of that lease, for the remaining years of that lease. Okay, so you can do the math and, in terms of the exposure that you may have with that personal guarantee. The only caveat here is if they're able to obtain a tenant for the remaining of the balance or whatever a time period is, you're only liable for the amount that it was past due plus the amount that was vacant. But you're not liable for anything beyond that they were able to obtain a tenant. And again, those are things that an attorney can help you as well. Commercial leases are, as I mentioned to you before, are fairly complex. And it's not something that you should handle on your own, unless you're an attorney who has experience with this. I recommend you get an attorney to handle it for you. And even if you're an attorney, it's good not to represent yourself in court. So let somebody else handle it for you. The exposure also includes attorney's fees. So you have a situation that you get sued for the balance of a lease or a breach of contract in this case. Not only if you do not prevail or work out some type of settlement with the landlord, not only you're liable for that balance of the lease, the past due amount, which are the damages, but also you're liable for attorney's fees that of the landlord that you would have to pay. So not only have to pay your own attorney's fees to represent you, you'll have to pay also the landlord's attorney's fees as well, plus the judgment, the damages for the breach of contract. So lease agreements are very important for a business. And for the most part, if you pay your lease and you keep the premises in good working order, you're not going to have an issue. They do happen. There are occasions sometimes that the landlords did not meet their obligations, that they did not repair property they were supposed to. They did not keep the premises in the conditions that they promised in the lease. There may be conditions that you're talking about a zoning issue or the code violations issue. That's something that should have been disclosed to the tenant, and they should not be leasing a property that has code violations. A case like that, it got resolved, but that's something that the landlord should be able to lease that premises to you free and clear of all encumbrances. That includes code violations. My recommendation when I talk to clients that are looking to lease, check with the city. Before you sign something, say, you know what, get a blank copy of the lease. They'll give it to you. Say, go to the city, talk to code enforcement, talk to the zoning department, or whoever does the business tax receipt, and say, listen, I'm looking into opening this business at this location. This is the address. Okay. Can I run this business at this location? Yes or no? Also, you can even, in most cities now, you have a website that you can actually type in the property and you're able to find out whether the property has any code violations or zoning issues. So you can pull that up. So those are things that are free, just requires maybe a phone call or going online for a few minutes and looking it up. But it's something you do before you sign a lease. We also recommend, which I mentioned this before you go into a premises, get an AC company to inspect the AC. It's worth $200. And in some cases, they do it for free because they want you to sign up a maintenance contract, and that is fine, but it's worth doing it. And if you are responsible for electricity, plumbing, get an inspector there to inspect everything that you're responsible for before you sign that lease, just to make sure that everything is in working order. And if there's something, when you get that report back from the inspectors, you can tell the landlord, listen, I find out that this unit is about to go out. How do you want to handle this? Okay, I'm not going to sign this lease for the next 5-10 years when I have to replace this AC. So why don't we go ahead and do this? You replace the AC when it's needed. Okay, or we'll cap my repairs to say $250 and I get a maintenance contract. So it limits your exposure, and these are ideas, of course. It limits your exposure as to your potential liability for that replacement of the AC in the future, because at some point we'll have to be replaced. It's just an example, but it's worth spending a few dollars to make sure that before you sign that lease, you can actually operate the business in that location. I can share with you. So what happens if you receive a letter from the landlord or an email? Okay. In some cases, you might be able to resolve it yourself if it's something that does not require legal, say there's a past due payment and you're about to make the payment. Obviously, that's not require a legal involvement because you can get it resolved with the landlord directly, the property manager. If it becomes an issue that you receive a notice of default from the landlord or the law firm, I think at that point might be the point to call an attorney to help you handle or respond to that letter as opposed to you handling it yourself. Early intervention by an attorney can avoid a potential litigation. I'm going to repeat that. Early intervention by an attorney on your behalf can avoid potential litigation. So don't try to do everything yourself. And if it's a situation that you're being threatened with a lawsuit, and those default letters is a threat to a lawsuit, those letters to evict, to vacate the premises or have a potential eviction or is a threat to a lawsuit. So if you receive a threat to a lawsuit, whether it's via email, most likely it'll be done via mail with certified mail because they want to have a record that you received the communication that is required anyway. At that point, you want to pick up the phone, call an attorney. Listen, I got this letter. I need help with this. Let's make an appointment to talk about it. And then attorney can help you navigate and help you try to resolve that before it goes into the next stage. If you ignore the letter, you can guarantee that the next step will be the lawsuit. The letters give you a certain period of time to cure the default or to respond. So by having that, you don't want to handle that yourself. Okay? You can tell them, I'm going to get an attorney, I'm going to handle it. You call an attorney immediately, don't wait to the last date of the response to contact an attorney. Early intervention by an attorney can help you avoid a lawsuit from the landlord. If you receive the lawsuit, obviously you get served with the lawsuit, my advice is to contact an attorney immediately and don't wait. And don't handle it yourself. I think this is good for today. I appreciate you. I hope this information was helpful to you. Again, lease agreements are fairly complex documents. They're for the benefit of the landlord. They're not for your benefit. You do have some rights, but you have to understand what you're signing, understand what your provisions are, and you can also negotiate some terms when you renew your term of the lease as well, and also when you're obviously getting into a brand new lease. If you have any questions about any of these topics that I've spoken to today, my email is rich@richsierra.com. Again, it's rich@richsierra.com. If you want to give us a call, my number is 866-842-5202. If you have any questions, any legal needs, my website is Florida Small Business FSBLegalCenter.com. We're also on Facebook at FSB Legal. If you want to watch this video, this podcast through our video, through our YouTube channel, it is youtube.com/Richard Sierra. Remember to check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for it in local bookstores as well. In fact, I have a section there on lease agreements in the book. I want to check it out. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.